Welcome to the Laughing Litigator.
Hey everybody, welcome back to an all-new episode of the Laughing Litigator with attorney Ray Hsu. I am your host, Mike Leon. My buddy Ray here, he spent over a decade wrestling with California's employment laws and somehow still's got the energy to laugh about them today. Today's episode, we're going to ask Ray the big question. Is California a hyper-regulated nanny state or an under-regulated Wild West? Or is it both? Depending upon which labor code section you look at. Here's the thing about California. The labor code could be its own Netflix series. One episode about the water breaks, another about shade breaks, and then a cliffhanger where you find out the temperature is different indoors and outdoors. And Ray's going to explain what all of that means in just a second. Ray, it's so good to see you as always. Let's talk about California's labor code law. Why does it feel less like a rule book at times and more like a comedy sketch that's been written by too many authors?
Thank you for having me, Mike. To answer the very first question, well, California is not just an overregulated nanny state. It's becoming an overregulated daddy state. Well, I will tell the difference later.
Okay.
And to answer the question at the end. I like to do that when there's a compound question. It's still being written. It's just like Star Trek. If you ever watch Star Trek, it just keeps going on and on and on and on, ever changing, everlasting, never ending.
So Ray, then I've heard you as well describe it a little bit as like a policy puzzle. What makes it so hard for people to piece this puzzle together in terms of California's labor code?
I can answer that. I'll start with the 2024 heat recovery pay of California labor code. We are not going to talk about it because it's pretty new. And also, you can actually Google it or have AI to explain it to you. And if they can do it, then you don't need to listen to me. And then but I want to talk about this California labor code that suddenly had this heat recovery pay in 2024, signed by our Governor Gavin Newsom. It's just like a puzzle,
I want to dig into the heat illness rules in that state. Why does California, and explain to our audience why they do this, why do they treat indoor and outdoor workplaces so differently?
If you look at the statute, you'll feel like, if it's indoor, it's certain Fahrenheit, then you need to provide shade, you need to provide water. If it's outdoor, it's like at a different Fahrenheit, then you need to provide shade, you need to provide water. Wow, it sounds like the law is really catering to the workers. But on the other hand, isn't this something that common sense would resolve it? Why do we need a statute to tell us that, we need a water here, and we need a shade there? If it's over 81 Fahrenheit, then the workers must stop. If it's over 86 Fahrenheit, the workers stop. If that's the case, what about 85.5 degree Fahrenheit? Or what about 82 degree Fahrenheit? And they don't explain any of this to you. And then they just come up with a penalty if you don't follow it.
That doesn't make sense to me. Some of the requirements, though, like you just mentioned, they sound oddly specific. How do you explain those kinds of details to clients then?
This is why I said to my clients, use your artistic judgment.
Okay, expand on that. What do you artistic judgment? How?
For example, if the statute or the regulation said the place has to be large enough so the workers don't touch each other, well, how big is large? These kind of stuff, I have to not just lecture to the client, I also have to care for their emotion. Do you know why? Because I can give you an example. A lot of time in deposition, you know what a deposition is, right? In a civil litigation, you call somebody deposition, and there's a court reporter, type out every stuff you want to type. And one time there's a proper taking a deposition against my client, and then he said, I want to request you to because it's on Zoom, okay, and the guy is in Shanghai, China, taking deposition of my client and me in Los Angeles, California. And he said, I want you to have, I don't want you to sit too close, so you will pass on some message to your client when she speak. I want you to have at least one person space between you and him. And then my response is, what is one person space? I don't understand a word you said, and I will still consider that as a request, and the request is denied. That's called artistic judgment. So you'll figure out.
Ray, I wanted to ask you because we talked a little bit about California, but Texas and Arizona, they have similar guidelines too, but they don't really have any real penalties. What does that say then about California, that they threaten fines and other states just shrug?
It's not shrug. The other states are just giving a cold shoulder. Why am I saying that using these analogies? I'm telling you, because actually the heat recovery issue or heat stroke issue or employee getting illness because of heat, it's actually covered in workers' compensation statute. Let's set the blue state, red state aside. Okay, the before the heat recovery compensation statute or the regulation come out, it's already in workers' compensation statute scheme in all 50 states. So basically, this is another things that California wants to go step ahead of all 49 or 48 other states and then say, oh, I'm doing something that's so advanced, so futuristic. I borrow some future concept that I can regulate and tell you that if it's over 80 something degree Fahrenheit outdoor, then the employer must pay one hour extra to the employee. And the more we read into the statute, the more we feel like, oh, if this is not overregulation, what is overregulation?
It's true. Very good point. So then let me ask you, let's take two different perspectives. First, we're going to start with the employer perspective. Which parts of the labor code cause them the most headaches?
Let me take a look. Which one? Oh, I have the answer for you. Every single one.
I got it. They can keep this in if they want, because that's very funny. Okay, what about on the workers' side, Ray? You're making me laugh. Well, on the workers' side, which protections actually make a difference for them day to day, or which make a difference for them day to day, and then which ones just kind of look good on paper?
For workers' side, we represent a lot of workers. I begin my law practice by representing only employees, workers. Then the employers came back to me and say, hey, I fired my own lawyers, and so you can help me to deal with other employees' problems. I said, oh yeah, sure, why not? The money is the same, right? Well, okay, to answer your question, on the worker side, which protection actually makes a difference day to day, or which just look good on paper? Well, in reality, workers come to work to make money. Okay, the more money they make, they're happy. If they don't feel they make enough money, they will feel unhappy or they will leave. So these protections for these workers, unless they also want to look into the statutes like a lawyer, otherwise for them it's maybe none or maybe a little.
Do you think, Ray, that all this regulation in the state of California, does it actually make workplaces safer, or does it create the potential for more lawsuits?
Both, or all of it.
Okay, expand.
Well, of course, the regulations are well intended. It wants to make sure none of the workers, especially illegal immigrant workers, or underrepresented workers, or the underserved workers, whatever you want to call nowadays with these kind of labels. The regulation wants to serve these workers, so it's becoming a safer workplace. But the more you regulate, then you realize, well, not too many employers will actually read it. Then you add a penalty. So you just create more and more statutes for lawyers to help the employee to sue the unwary employers. And I'm telling everybody this, that please understand, I'm not complaining. I'm not complaining about anything. Thank you for making me rich. Thank you. Thank you.
So they made you rich, but if you had a magic red pen right now and you could rewrite one section of the labor code tomorrow, Ray, which part? I know you used a magnifying glass before, so maybe you have a red pen there. Which part of the labor code would you cross out first?
I will cross out. You know what? I have an answer for that. I will cross out our Governor Gavin Newsom's last name.
Explain what that means, please.
Okay. Before we go into politics, I want to tell my listener first. I'm saying this, and I heard a lot of the MAGA, the newsletter or MAGA agencies, and other very conservative news agency, if you will, say it's Gavin Newsom. Oh my God, this our governor Gavin Newsom is a really good guy. He really wants to do good things. But he was hijacked by the woke movement. He's being positioned as the woke movement savior as of 2025. So his hands are tied actually. So our governor is a good guy. Please don't call him a Gavin Newsom. That is terrible. Scum is a terrible word. But I have an opinion. Okay, even though I'm nobody and my opinion is totally insignificant, but I shall call our governor Gavin Nonsense. Thank you.
Ray, thank you for the time and insights on this. We truly appreciate it.
Thank you.
Thank you to everybody out there for diving into another episode of The Laughing Litigator with, you just heard him right there, Ray Hsu. If you want to reach out to Ray and the team, do me a favor, visit rayhsulaw.com today. Subscribe to this show. You're going to get more satirical breakdowns of law and politics like new scum and nonsense. Don't forget, leave us a review, share this episode, somebody who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.